From supplementary list for orders with effect, item 1, first appeal filing number 529 of 2025.
In this case, notice I will prepare given that for both of them. So for two petitions are there, one for limitation petition.
Other defects have been removed. Court fees you have not filed. Filing number FA 529 of 25. Time till 19th of December is granted to the appellant to either to remove the surviving defects or to file appropriate petition in connection with the defects as pointed out by the office.
Super substitution. Why not? Super substitution is concerned. I am not facing this because after award, one claimant.
You first pay the bina court fees दिया आपका एक Either you file the either you remove the defects or you file appropriate petition. बस यही हम order और this order is payable.
हम बोलते हैं इसको नॉट प्रेस कर देते हैं आईडी डाल देते हैं फॉर
वो हम नहीं जानते अब आपका डिफेक्टिव पिटीशन है 19 तारीख तक जो करना है rather इसका डिफेक्ट जितना भी है 19 तक कर दीजिए एंड पोस्ट ऑन 23 दिसंबर
50 time.
हाँ 50 टाइम
नेक्स्ट केस में से
सेम
Item
ऑर्डर
2.
बताइए सीरियल नंबर 2
सीरियल नंबर
सेम चलिए दोनों में सेम ऑर्डर
Item 3, first appeal filing number 1593 of 2025.
यस
No time in this case.
सेम ऑर्डर
For this time,
आपको टाइम देती 19 तक टाइम
3, 4, 5, 6, 8.
3, 4, 5, 6. You remember it's a preemptory order. Either you have to remove the defects or you can file an appropriate petition. कोई ignore करना है कोई defect या कुछ भी करना है.
40 is on.
वो हम नहीं करते. आप अपना payment करिए. If you do the needful, it will be on 23rd December. 23rd December को ये सारे मैटर सप्लीमेंट्री में डाल दीजिए. लास्ट वर्किंग डे है अगर फॉर्मल एडमिशन होगा जो होगा कर देंगे उसमें. नेक्स्ट
Item 7, first appeal filing number 3360 of 2025.
सेम ऑर्डर कर दीजिए. आई दे
Yes. Certified copy of DT should be filed.
so you do it by 19. I pass a preemptory order.
Item 8, first appeal filing number 10490 of 2025.
Same order.
Item 9,
Being permitted to indoor to file the sale before the land is disputed. Objection is regarding the pecuniary jurisdiction.
Filing number FA 10637 of 25. The learned counsel for the applicant is present. He submits that there is an office objection with regard to pecuniary jurisdiction in the present case. He submits that the first appeal is required to be filed before the learned district, before the district court. And accordingly, he seeks permission to withdraw this appeal to file, to take appropriate steps as per law. Considering the submissions, the appeal is permitted to be withdrawn with the liberty to the applicant to take appropriate steps as per law. So far as the certified copy of the judgment and decree is concerned, the same be returned to the learned counsel for the applicant after replacing the same by a photocopy certified to be true by the counsel.
sign. Item 10, first appeal file number 13011225.
Same order.
From tail list for order with defect, item 1, CMP 281 of 2024.
सेम ऑर्डर इसको भी 23rd को एकदम सेम ऑर्डर है सब सप्लीमेंट्री लिस्ट में आएगा 23rd।
Item 2, first appeal file number 11526 of 2024.
सेम ऑर्डर।
Item 3,
सेम
item 4,
सेम ऑर्डर।
item 5,
सेम ऑर्डर।
item 6,
सेम ऑर्डर। कोई बात नहीं प्रेम्प्टी है ऑर्डर 19 तारीख तक आप कर देंगे और अगर आपने डिफेक्ट रिमूव कर दिया तो 23 तारीख को रहेगा मैटर। अगर कोई ऐसा डिफेक्ट आपको लगे जो आपको लगे कि ये नहीं रिमूव हो सकता है उसके लिए आप एक आईए फाइल कर देंगे तो भी आपका केस डिसमिस नहीं होगा। लिमिटेशन वगैरह है सब में ठीक है।
item 7,
सेम ऑर्डर।
item 8,
सेम ऑर्डर।
item 9,
सेम ऑर्डर।
This case not degree is not being made.
You have to file an appropriate petition. You either you remove the defect, you file an appropriate petition for
Degree
ignoring
has
the
not
defect.
been made yet, Your Honor.
You file an appropriate petition. I will ignore the defect.
Yes.
नहीं फाइल करिएगा तो आपका DFT हो जाएगा ध्यान देंगे।
3 weeks time.
हम आपको 19 तारीख तक टाइम देंगे 3 वीक से ज़्यादा।
item 10,
सेम ऑर्डर।
item 11,
सेम ऑर्डर।
item 12,
सेम ऑर्डर।
from supplementary list space case item 11, first appeal 367 of 2018.
इसको टैग कर दीजिए। इसको टैग कर दीजिए। पूरा अच्छे से टैग कर दीजिए धागा लगा Just face the other side. Waiting outside. मैं बाहर धूप
She's trying to always do service. Like we manage the argument, we can find one of the
No,
questions.
just a moment. Let them come. Have you also prepared your notes? You exchange,
Yes.
give it to them.
Petition to find from my company. What will be having.
Let me get it. Tag होगा? सुरेश जी को बुलाएंगे। Ask him to be here.
only just one.
एक चीज just to tell you, ये ना on behalf of the applicant लिखना जरूरी है. तो जब हम लोग उसको देखते हैं ना तो कंफ्यूज हो जाते हैं किसने फाइल किया. I'll just check.
Appellate in first case and respondent in other cases.
Yes, I've just written you. You know.
Then why did you
आपका दिखाइए. Respondent,
I have given the copy.
you provided a copy. I'll give my copy.
And one thing I will just point out from the bottom, I have indicated the page number. This page, whatever page we are relying, bottom information will find attachment page number 26.
Okay.
So next page also you will find page 18. What we are referring in our notes, that page is highlighted.
That's good. It's a new system.
The youngsters are now taking serious. So
वो लोग अपना पेपर रिसर्च पेपर बनाते हैं ना.
they always will take me in a trap that एक बार बोलेंगे index तो sir I have done this.
नहीं, आजकल नया नया स्टाइल है. ये तो अभी इन्होंने वो उसमें नहीं लगाया है वो क्या हाइपरलिंक.
Hyperlink.
इन लोग का होगा सिस्टम में हाइपरलिंक है ना. हाइपरलिंक किए कि नहीं? तो हमें क्यों नहीं देते हैं सॉफ्ट कॉपी? आप दोनों हमें सॉफ्ट कॉपी प्रोवाइड करेंगे.
हम दे देंगे.
आप सॉफ्ट कॉपी प्रोवाइड करेंगे हमको.
Soft copy pen ready?
हाँ, you can type.
I will
We
provide.
use it.
I-
Why should my typist spend time
Yes,
in
because
typing?
ultimately the fact
It's
is
more convenient to me.
नहीं, सॉफ्ट हार्ड कॉपी तो लगता है पुराने जमाने के लोग.
Hard copy is very difficult nowadays to navigate manually. It's very difficult.
सॉफ्ट कॉपी प्रोवाइड कर देंगे. In your pen drive you can
I'll
and you can get back the pen.
Because
No, sure.
I am using my tab ready and everything I just differently.
That's it.
So that is liquid test. They are also
It's very convenient.
No, now they are doing what several documents. No, now they are creating link in the one document itself. So every time you did not go back, you press the link in the page, you go back to the other documents.
You are taking the index here and just mark it, and the moment I touch, it comes to the image, and that is very convenient.
That's it. I also use liquid text at times, not in the books.
But for you, most of the records are in physical form, so it's very difficult to navigate from my lady to go to different
But
pages.
ultimately, every record has to be visited before passing to the
For these voluminous records, I think some physical things are required.
Physical-
Actually, what happens that when we navigate through the records, then at times anything which did not transpire during the court proceedings, that catches our eyes.
Exactly.
So that has its own advantage.
True. Physical is any day physical penalty, but to make a submission because we just want to very quickly navigate from page to pages. So
Yes.
it's very convenient for argument, but for comprehending the documents and making judgments penalty, it's always
Now, actually, suppose that they have concluded their argument, so I am in region. So whether
Yes.
they will like
You
to
see, I will not stop anybody from giving additional points. Right? I will not stop anybody. And if there is anything, because the different submissions I have already taken, if anything in addition you want to submit, I will record it here itself.
just to sum up and plot parameters what we argue.
First, you rejoined.
Yes.
You have included in your rejoinder. Your
One
proposed
fact that they
rejoinder.
have said, they argued that exhibit 4 and 12, saying that both are, if leadership will kindly come to
They are primarily relying upon exhibit 4 and 12.
12.
Correct.
That we have answered. So 2 points they say that these are ward number 3, 4, 5 and 6. 4 is ours. Ward 3, 5 and 6 is subject matter of exhibit 4.
And exhibit 12 is
ward number 3.
3.
And our case falls in ward number 4.
What?
And an impression has been created that these are all contiguous areas. So we have meticulously, and from map also if I point out, these are not contiguous. Ward number 5 and 6 is Govenda, and ward number 3 is opposite to Ranchi.
Okay.
This fact will transfer from the order also and from the map that has
Map
been
also.
exhibited.
So it is not adjoining to ward number 4.
That is miles away.
Let's
It's
have a look
town.
at the map.
Yes, yes, please. Exhibit 1. Now, since we are not having the hard copy here, but shaded portion is the town area.
Ranchi, you can mark it. और जो है ना वार्ड नंबर थोड़ा सा पेंसिल दीजिए, ये रेड पेंसिल.
Ward number is not calculated, but that will be from the judgment. Yes. The left column, that should be 5. That is the indication legend. Left margin, legend, town area is reflected. Left, down.
Down,
I have
Ranchi,
highlighted left.
Ranchi Court, Wali.
No, I have
Yes,
indicated
right
legend,
inside.
Ranchi down, shaded. The things are then.
Gari,
No.
Khatanga.
First of all,
But shaded area is
the
Ranchi.
town.
That's right.
The town that is shaded area, that is on top right, it is expanded from. Top. Now you will additionally find that none of this I have highlighted is in the town area. Rani, Langan.
But evidence has come that it is adjoining to the town.
No, so
On the periphery of town.
and we have measured on the scale is given. It is 7 miles away from the town. That is string and measurement scale is given in top. 1 inch is 1 mile. Top, you will find the scale. This topo said.
But National Highway is just adjoining. Gari.
Yes, but that is not part of town. That what I intend to submit, that what is reflected from this exhibit 1 is Doranda is within town, Machi Club is within town. When I place exhibit 4 and 12, these are within town, heart of the city. And these are the areas of 71.
In this Ranchi town, Doranda as such has not been mentioned.
Top expansion is there. The addition will come on top right.
Top right, Mora.
No. Top is sheet ka ekdam top.
Sheet the top.
Right side, right? That is expanded form. It is given there.
Ranchi town.
Yes.
Doranda is mentioned over here.
Yes, that is taken in Ranchi town. That is expanded form. That is township.
Chutia, Hatma. Alright. So from the
One,
map,
yes.
you want to say that this is
One
Quite
it is
away.
1 mile.
yes.
Is pre-measurement I had asked my office. They have taken it. It is almost 7 mile dot to dot. It comes. Now, factually also when I place exhibit 4 and 12, we should go through it. We find that Ranchi Club is heart of city. Opposite to that, Ward 3 and Ward 5 and 6 is Doranda, again heart of the city. And 71, just I am inviting your leadership that 71 7 miles away means almost 10 kilometers. Take it like this. If converted to kilometer, it will be 10 kilometers away. So these are all development we have experienced after coming of state of Jharkhand.
Ranchi town towards Gari is intercepted by an area called Kokal. It is intercepted by an area called Kokal.
Kokal.
Kokal यहाँ दिख रहा है.
Yes, Kokal.
So it is not adjoining also, but
It is not in that.
if we just see, but it is falling in the municipal area.
At that point of time, I don't know whether municipal notification to this effect because this exhibit.
No, but as per your case also, it is ward number 4.
Yes, then it is definitely
It
municipal.
is definitely municipal area. You
But
can't,
in any-
maybe it is not in Ranchi town, but it is within the Ranchi municipality. At least that much you should have.
Agreed. I cannot dispute the facts. Now my point of submission is 71 city 10 kilometer away. I take it like this. So valuation of the property cannot be that of the basis of the heart of the city. And there is no mechanism because in leadership, this all areas have developed after 2000.
No, let's not
We
see
will not go into that.
things which are not from the records, please don't
So
see.
no. So 2 points.
I do not want any of our personal knowledge should enter
It should
into
not
this
be.
record.
It should not be. But things because what is being argued is the development. That is also not part of it only.
No, they are not saying development. They say that as per them also, it is in the periphery of the Ranchi town, and it has got great potentiality of development. Future prospects are very high about this property. This is what their argument is. They did not say that it is a developed area. Nor do they dispute that at a time of requisition it was agricultural land. They do not dispute all that.
So then I 8.3, I will not repeat that. 8.3 is sufficient in its expression. 71, whatever will be the market value, it has to be taken into consideration. Because they are selling the compensation determined by the acquisition officer.
When we talk about market value of 71,
Yes.
right? Then the nature of land as in the year 71 is to be taken into consideration. Because
3 does not say so. With all due respect, 3 does not say. 3 says that nature of land will remain agriculture, it cannot be commercial. Even in today's, when we take commercial plot, its rate of registration, rate is.
it may not be commercial, but still,
It is
when we talk
agriculture.
about the market value of the property,
Yes.
then the nature of the property as it stands on that particular day has to be. You can't segregate both the things.
No, I say.
It is one. You see, the previous law was that on the date of acquisition, the value of the property was to be taken and it was to be multiplied by a particular number. That was the previous section. But post amendment, it is nature of land on the date of acquisition and the market value on the date of nature of land at the date of acquisition and market value on the date of acquisition.
Now it is that what I argued, 8.3 is there, I won't repeat that. Now, so exhibit 4 and 12 will not come to their help because my submission would be that all other judgments which they have relied, probably on point of computations, are pertaining to land acquisition. And land acquisition act, as I have already placed recognition, is that this is a special law, self-contained code, so that principle cannot be borrowed.
That distinction between the Land Acquisition Act and this act was drawn primarily on the basis of section 23A.
23.
That 23A provisions are not there.
Not.
So apart from that, so far as the computation of market value, the parameters to be taken into consideration, the exemplars which are to be taken into consideration, the future prospects of the land, etc. Those parameters are the same.
Yes.
There cannot be any distinction between two. Of course, merely because somebody had gone to the court and there has been an enhancement, this will not give them a right to seek enhancement.
At the base, it can be an element of evidence, but that will not be a conclusive part for the
You
person.
see, what is section 23? 23A says of the Land Acquisition Act
Yes.
that if anybody has gone to the court and others have not gone to the court and there is an enhancement in the matter of grant of compensation, then it is the duty of the land acquisition officer to give similar relief to the others irrespective of the fact whether they have come to the court.
True.
That kind of special provision
Is not.
is not there. That is the only distinction.
Only distinction.
Rest is the same.
Yes,
Rest is the same.
At least principle will go
So
same.
it is therefore anything akin to section 23A of the Land Acquisition Act is not a
So by exhibit 4 and 12, that principle of contiguity and determination of that amount will not come into
That-
picture
that-
independently.
that
That's
I
what we are
know.
saying.
that act.
And two things emerges out that one. That is
According to you, what should have been the parameter? According to you, which evidence are you going to rely on?
My report is there. I cannot.
Your
run away
report is
from
not
it.
an evidence.
My report is marked as an exhibit. It is an evidence, but it does not.
an evidence. Please, report is not an evidence. Even if it is marked as an exhibit, and let me just take you somewhere. वो जो judgment is- हाँ, ये वाला judgment, आप जरा देखिए. This one, appeal from original decree, Honorable Justice S.B. Sinha wala judgment.
Exhibit 4.
Exhibit. Para 15.
Para 50.
It is now well settled that the rate report is not admissible in evidence if the maker thereof has not been examined.
Somehow it is not my standard.
I am just reading it out to you.
Yes, yes, please.
It is now well settled that the rate report is not admissible in evidence if the maker thereof has not been examined. Simple.
So
You see, the person who is making the report, there are two things.
yes, that is section 90. Author of the document has to come forward,
Yes.
but in official capacity.
And
But in official capacity, suppose like in criminal jurisprudence.
no, there is a reason for that.
Yes.
That very same person is required to be examined. The reason being that he is relying upon certain salings. Right? And where are those salings? Do you want to say that anything, whatever is mentioned in the rate report, should be taken as a gospel truth? Where is the primary document? You have not exhibited any one of them.
If I,
And
if I
And how
make
do
a
we
small-
assume? And we do not know what is the nature of that land. What we had, those documents, those entities are not here before us for appreciation. So that we will not accept. Apart from that, which one is your best document?
on that point,
I will take it, but still,
as my submission.
I will take it as your submission.
Yes.
But apart from
Apart from that,
that,
there is nothing. Apart from that, we have
Exhibit
not.
9,
Exhibit 9 is their document which they have come from.
at best,
At best, their document.
whosoever has brought on record,
Because
the
this is-
document is imitated.
Exhibit 9, like exhibit, our exhibit report, that is also, they have,
Like they have furnished it.
yes, that is 97 statement. So that is one document, very true, that indicates a rate, that is in compliance of 8.3b also, if we can take it as an evidence, then on the date of acquisition, it is reflecting some rate, at least, and they have relaxed, so they are stopped from moving ahead of that. So these are the two material documents at the point of, in my humble submission. And my report is also marked exhibit without objection. And one small thing which I wanted to say, that same person need not require to, when works are done in official capacity, the persons
See,
who have come.
it is like,
If I take your addition to section 90 of evidence, it will be clarifying
No.
that who can prove a document.
no, it is not a matter of proving a document. The document is there.
Yes.
It is not a false document.
Yes.
He has proved it.
But
But the contents of the
Contents.
document, which you are relying upon, is subject to cross-examination.
they have not cross-examined me. Na.
The person who has prepared the report is not there before the court. It has been formally marked as
Anyway, that is my
exhibit.
submission of that. That is very correct. It is coming.
And
He is
you
not-
should have, the report they have placed, it is something which you should have placed on them. It is your document. Right? You have not placed it. They have placed it. If that report, whatever report they had, they placed it. That report must be
That report
accompanied with the sale deeds. Where is that?
That report has been dead by the arbitrator, holding that it is contradictory. He has returned a finding on the report. So it is not the case that the report content was ever doubted or questioned, or they have there, because arbitrator is having the power, he can summon the persons also. Instead of choosing, or he can call for document that I had placed yesterday, that power it's of a civil court is having all the powers. And he can summon the document.
And Union of India would do nothing.
No, when I will only travel into the disputed if anything is disputed. That is my submission for your kind consideration. So my submission is that my report was never questioned by them. Arbitrator has traveled through that report and returned a finding that it is something very giving contradictory because he has not considered the four sale leads, the variance in prices, that those things he have done. So that is a, so I am summing on their joining to their exhibit 4 and 12 two things that it is not akin to 23A, so it will not be taken into consideration, and there is a far away distance factually also. What they have placed as, though I am in municipal area, but it is a far away distance from where these lands were acquired. So exhibit 4 and 12 cannot form basis of determination of acquisition compensation in this matter. Now I take addition to the yes, I am taking to the point of determination straight away to my notes
Yes.
instead of
This is what you have to say on it.
yes. Quickly I will take
That's
this because
Okay, please.
whether the compensation can be increased for those who have accepted entire compensation without protest. It is in the case two.
Just.
One more thing before I just go into this, we have placed the Honorable Patna High Court judgment. CWJC judgment yesterday. We have also enclosed to this. So Honorable
You just read it. You just read it once. Your written submissions.
it is not in dispute that Honorable Supreme Court was pleased to appoint the arbitrator for all the land users. However,
No, it is your written
Chronology.
submissions. Yes. You just read it. There may be some query. That's
yes. Land forming subject matter of instant appeal requisition in 41-42. Soon thereafter, the land was acquired in the year 71-72. Compensation was paid to 80% of the land user by 1975 without any protest. However, some land users who were agreed with the compensation accrued Honorable Patna High Court by filing a petition in CWJC number 1590 of 91, 2257 of 91, and 2252 of 91. The state of Bihar North Jharkhand appointed an arbitrator by notification dated December 18, 1992, only for adjudication of those who had accused the Honorable High Court. The aforesaid notification was notified on June 5, 1993, wherein all the land users, that is, apart from those who had accused the Honorable Court, would get their compensation adjusted. The notification dated June 5, 1993 was essayed before the Honorable Patna High Court in CWJC number 8131 of 93. During the pendency of which the notification was cancelled on November 18,
Just a moment. This notification dated 5th June 93 was essayed by whom?
This was by us.
By Union of
By
India.
you.
Okay. Yes, please.
And during the pendency of which notification was cancelled on November 18, 1993, wherein the appointment of arbitrator was again restricted to only those who were initially approved honorable. In the third round of litigation, the notification dated November 18, 19 was challenged in CWC number 22. This is by the
Claimants.
Yes. Wherein the land user sought to challenge the notification on basis of discrimination. The Honorable Court was pleased to dismiss the writ petition by order dated January 10, 2000. This I will close to this. This was assigned to the Honorable Supreme Court in Civil Appeal 7152 of 2012. The Honorable Apex Court was pleased to appoint like an arbitrator for all while clearly expressing that it had not expressed any view on the merits or demerits of the case. In terms of thereof, a first notification dated February 23, 2013 for all the land user was issued. This judgment is also there. So, the award from which the appeal arises. The instant batch of appeal arises out of the award passed by arbitration case number 5 of 13 passed by the sole arbitrator on the district by R.K. Marathia, wherein the sole arbitrator has been pleased to direct the payments to be paid compensation of 41750 per acre. The learned arbitrator has further been pleased to award solution of 20% on the awarded amount and give 9% interest on the entire amount from January 1, 1976.
Why this January 1, 1976?
75 to 75 we paid them. So he took the cutoff date to be 76. If you come to first page, we have said it was paid up to 1975.
Just a moment. On the entire amount from January 1st, 1976.
Yes.
Not on the differential amount.
He has calculated that differential amount. He has reduced in his final award. Whatever was paid, it was reduced.
Reduced, and it is primarily on the differential amount.
Differential.
The solatium is also on the differential amount.
No. If I take the differential award, yes, this would be. On solatium interest balance, he has prepared a chart. That is award. That is at interval page. Running page 45. It is last part of the award. 35, page 35, internal page 35 of it.
Internal case 35.
Yes.
Internal case 35.
Yes, award retribution money, award.
Yes, award.
Then he writes compensation for land market value at the time of acquisition collected for all types of land.
That's right.
Then he writes deduct the amount paid by the competent authority.
Okay.
Then A minus B is the payable amount that is add
Reducing balance.
reducing balance. Then he writes add
Solatium is on the differential amount.
differential amount that is C.
Solatium is on the differential.
Differential. Then he writes B land that will come to this amount. Add simple interest 9% per annum from 1176 to 31/7/2014. This will be
So
amount
9% interest
on solution as well as the differential.
on solatium as well as the differential amount.
And so
Prior to this, there is no interest component.
prior to this,
There is no interest component. On the award, there is no interest component prior to this. So
Prior to-
till F, you may not have any grievance at all. If solatium is sustained.
is solution.
Till F, you may not have any grievance. Correct?
This if quantum is also sustained.
That's right. Let's take it.
Now
The
let's-
computation part.
Yes,
Let's
in
take it.
context I am saying that
Yes.
yes, up till F there is no issue. There comes 9% that is also written on solution.
That's right.
And
9% is included.
included in the principal and then comes total. The awarded amount at G must be equal to so and so. And then he says that simple interest 50% per annum amount on G from the date of award till date of payment date.
This is also the bone of contention.
Yes. Interest on interest part of it.
Interest on interest.
So on this award, three things will emerges out. That one, if quantum survives, then the second issue is where the solution is to be added from that date only because delayed it is in a sake of compensation, so it should have come to the end of the 20%. And then 9% adding to solution is again we are penalized on the penalty. Solution is otherwise not in the act. Solution is only given for the purpose of protracted
not a
Latches.
penalty.
No,
It is
Compensation.
to compensate them on account of your
delay.
lapses.
You delay is
Some kind of damage,
damage.
not a penalty. Some kind of damage.
73 also contemplates that what we say that special damages, the kinds
Some kind of damage
damages in the shape of
at least.
penalty. I will be arguing this is shape of penalty.
It is not a penalty. It is just a damage.
Damages in
Penalty does not have any quid pro quo, in the sense that there is no comparison. This is basically not a penalty, but it is
take us
damage.
yes, I agree to that. Then so this is the shape of the point of determination.
Now you come back to this point of determination. Yes, 1.
Unit shape
3.1.
3 point. Whether compensation value. It
Yes.
is not in dispute that on the Supreme Court has been placed to appoint the arbitrator for all the land users. However, in its order dated so and so, similarly, was pleased to clearly hold that it had not expressed their opinion on the merits of the municipality. It is submitted that Honorable Supreme Court of India had not gone into the merits of the case. However, Honorable High Court of Jharkhand, in its order dated August 10, 2008, passed its user and crystallized all the facts. The Honorable High Court had categorically held that most of the land users, including the writ petitioners, had accepted the payment without protest. The Honorable Court has held that they are not on the same footing as the other persons who are told Honorable High Court initially. Though the said order was set aside, but the proceed fact borne out from the record. As such, facts will be material for the adjudication of the case.
Kindly pause for a moment. If we record a finding here that those who have accepted the payment without protest, they could have been on the basis of the judgment of the High Court. Then the very fact that they have been sent for adjudication becomes meaningless.
We have dealt with that. What is their proposition? We have dealt with that. It is submitted that an arbitrator had failed to adjudicate the issue pertaining to the entitlement of such person who received compensation without any objection or demand, solely on basis that Honorable Supreme Court had been pleased to appoint arbitrator for such persons and that form K was never executed. Union should be instructed. In the attending facts of the case, submits that there was no arbitrary dispute for the said person as their case fell within the ambit of deemed acceptance. The appellant places reliance on the award prepared by the competent authority. So all the award there is no protest or limited to that. The Honorable Supreme Court of India in case of Union of India versus Bhushan has categorically held that despite the agreement under Form K not being executed where there is no communication conveyed to the central government and no protest refusal while receiving the compensation, then in such case delay would not be attributable to state and it will be a case of deemed acceptance. However, the factor to determine if there
Just
was
a moment. I would like to see this statement. 4.
Satyavati two judgments, and we have also quoted that. You can see the just
Okay.
then it will be.
Alright. I would like to see. Please,
Yes,
you
both
are
the
required to place this down.
Yes, both Satyavati and this.
That's right.
However, the factor to determine if there was a delay in appointment of arbitrator would be a demand which is never from the side of the land user. The relevant portion of the judgment is reproduced for ready reference. You have quoted the reading of this rule does indicate that after an award has been made, the competent authority is enjoined to communicate its offer in writing to the person interested. Such interested person is also enjoined, emphasized by the use of the word shall to communicate within 15 days of the receipt of the offer in writing to the competent authority. His acceptance or otherwise of the offer. If he accepts the offer, the competent authority is further enjoined to enter into an agreement on behalf of the central government with him in Form K and to pay compensation awarded to him. If the interested person does not accept the offer nor communicate in 15 days of the in writing, the competent authority his acceptance or otherwise of the offer, the competent authority is enjoined to submit to the central government a report setting forth the full fact, in particular the nature and extent of the disagreement between himself and the interested person, and should forward with the report all connected papers of the central government. He is also enjoined to deposit the court the amount offered by him to the interested person. Thus, it may be seen that the interested person is enjoined to communicate within 15 days from the date of acceptance, receipt of acceptance, or otherwise in writing of the offer made by the competent authority. The ratio of Sito Devi, so and so, on which reliance was placed by the counsel for the respondent, has no application to the facts of the case. Therein, it was found that by this court that in fact, case of the appellant is that they had accepted amount sent to them under protest, to which there is no demur, and therefore they did not sign the agreement in form K which was sent to them. In those circumstances, the court had held that the competent authority and the central government ought to have appointed arbitrator to determine the compensation payable to the claimant. In this case, however, since admittedly the appellant had not communicated their acceptance or otherwise of the offer made by the competent authority, there was no duty cast only to appoint arbitrator under 81B of the Act. In paragraph 79 of Hari Krishna Koshla's case, so and so, this court considered the observation made in Harvan Singh Sani Devi decided on so and so. What was stated in Hari Krishna Kosla cannot assist the respondent because the general issue laid down in that case, the provision of land acquisition have no application to the acquisition under this Act, and payment of solution in interest cannot be customed since the Act did not provide for payment of interest and solution. This squarely applies to the facts of this case for the reason that there was no laches on the part of the appellant in appointing arbitrator which was assumed by Hari Krishna Kosla. We have said about there being no laches in appointment of arbitrator in the case at hand, as obligation to appoint arbitrator arises where the interested person communicates his non-acceptance of offer enjoined by Sub-Rule so and so. The requirement of Sub-Rule 6 to submit a report to the central government where the person to whom offer has been made does not communicate within 15 days cannot be regarded as requiring the central government to appoint arbitrator on knowing about the fact of non-communication of interested person. According to us, something more is needed to require appointment of arbitrator. The interested person must communicate about his non-acceptance of offer, which was not done here in the case at hand. In Harishikar Kosla case, this court had assumed latching on the part of the central government due to delay of 16 years in appointment of arbitrator. You would not draw such presumption. In the case at hand, it is admitted that 80% of the persons have received compensation without any protest or demur, and as such, they are not entitled to any enhanced compensation. The requisition and acquisition of immovable property does not provide for any specific period of limitation for raising, but clearly stipulates that the acceptance or otherwise has to be communicated within 15 days. It is a specific case of union that even though the compensation was accepted by 80% of persons without any protest or demur, there is no communication of any objection from their side. The relevant portion of the judgment of Union of India was Satyodhi and other is reproduced as under 40 level. The controversy raised in this cases is squarely covered by the judgment of Union of India was following the judgment, we are constrained to hold that since no action has been taken by the claimant in communicating the objection for non-accepting the award within the time prescribed under it, it must be deemed that they have accepted the award. This is what we have to do. Consequently, the omission to appoint the arbitrator under 81B by the Requisitioning and Acquisition Act in Immovable Property Act read with Rule 9(1), Rule made under the Act is not vitiated by error of law. The High Court therefore was not right in directing in the appeal order the appointment of an arbitrator. The land users have failed to bring on record any evidence to substantiate their claim that compensation was accepted and protest for them. Reliance is placed on the judgment of Honorable Supreme Court in the case of Union of India vs. Secretary, wherein the Honorable Apex Court has categorically stated that where no action has been taken by the claimant with respect to communicating their objection for the award within the prescribed 15 days, as mentioned in Rule 9(6) of the Requisition and Acquisition of Immovable Property Act, it must be deemed that award has been accepted. Thus, the cases of the appellant is that in the present facts of the case, there was no occasion to appoint arbitrator for the purpose of determining the compensation for this class of person. It is significant to state that purpose of appointment of arbitrator is only to determine compensation, and when the competent authority determination of compensation is accepted without any objection. In such circumstances, there is no call for appointment of arbitrator. Moreover, the prescribed time under 52 is 15 days. The claim are also barred.
With this, the claimants, they have said that they have accepted the award under protest. They have made us oral statement.
Oral statement here, but
They have
award
this-
is before your head.
That's
The award does not indicate any protest. Those who have not accepted, that is running blank. Those who have accepted, I am putting a question to
By
myself.
you are putting a signature that amounts to acceptance without protest.
Protest is a positive action that rules prescribes. Rule is framed under that. Rule is not under challenge.
And the mode
Whereas
mode of protest is also mentioned
So they have to communicate it to us.
according to you.
Yeah, that is the rule. That rule mandates rule says. So I say that protest cannot be inferred. And let us understand that
Acceptance also cannot be inferred.
no, acceptance by conduct is always inferred. That is what Supreme Court says. That you don't communicate, you receive entire amount. Enhancement, suppose I fix a compensation, suppose I fix what 2 lakhs. They accept it. Tomorrow they will come and know it was 3 lakhs. So they, while receiving this, it should have been a protest. So not giving a protest means a positive act from their end. And how positive act? You have to communicate. Now you come forward, you receive your entire compensation way back in 73, 74. Then you remain silent. 15 days rider is there. They cannot plead that they were not aware of this entire transaction. These are all paper publication, communication, receive of award in their account. So no communication. So I say that in absence of any communication, it will be taken to be deemed. That is how I am trying to understand the judgment of Honorable Supreme Court.
By virtue of appointment of arbitrator, that does not mean that all these objections have been waived at any stage.
Yes.
Mere appointment of arbitrator
Will not make the case of a
will
last.
will not enjoin upon the arbitrator to decide compensation with respect to even those who had not raised any protest.
I vote on. This is my contention. This is my.
Every issue was open for
Open
the
for the
arbitrator to
And
Consider.
one judgment. Anyway, that one judgment for the reasons what I had said
3.2.
will be due. 3.2. Whether appellant can be held liable for any delay. It is submitted that an arbitrator is mandated under the scheme of the Act was appointed upon the direction of the Honorable Court. The report reflects that first set of litigation of 1991 was filed after the lapse of almost 16 years by the land user. There is nothing to show that prior to the said period, any demand representation was made by the land users for the appointment of arbitrator. It is submitted that Honorable Supreme Court in the case of any security that if no demand is made, there is to be deemed acceptance of the compensation. The same is evident from the award which is exhibited by the union. This fact is further evident from the factoring matrix recorded in the order dated so and so, passed by in Virendra Mahatam versus so and so, the relevant portion. This we are taking here. Virendra Mahatam versus Union of India.
Yes, please read it.
That it is a specific case of the respondent that the petitioners have already received their share of compensation for their land long years back without any minimum notice. Though this is denied by the petitioner, they have not produced any document to show that they have received compensation under protest. And thereafter they ask an appointment of arbitrator. As a matter of fact, 951 of the aforesaid Rule 1953 provides that any objection to be raised regarding quantum, an application raising objection and requesting for appointment of arbitrator shall be made within the specified time of 15 days. Immediately, the notification was issued on 5/6/93, referring to the arbitrator only in the cases of petitioners and 400 petitioners, but also 753 cases without verifying the fact whether they have made protest earlier or asked for appointment of arbitrator. As such, state government, on noticing that notification dated so and so was not in consonance with the order of the High Court, rectified the mistake found in the notification and issued another notification dated 18/11/93, restoring the earlier notification referring the case of the petitioner of the earlier petition. This rectification cannot be considered to be wrong, especially when there is no document to show that 753 land users after setting aside of the ground after receipt of the compensation amount, have objected to the rate and asked for appointment of arbiter.
It
These
is
are
in
the
connection with the same.
Same, that went to Supreme Court. This has been satisfied. But for appointment of arbitrator, they lost here. That Supreme Court said that let them come forward before the arbitrator.
So everything was open.
Open and clearly last night it says not going into the merits and demerits of the case. So these findings which we are relying upon the High Court's judgment is limited. It is borne out of the record. It is recorded in the judgment that there is no protest from there. Now this fact they would have brought. This was before the arbitrator. This was a finding. They should have produced at least one sheet of document that no, this 753 was also had made a protest. So limited to that extent, Supreme Court has only covered the fact that arbitrator appointment, let it be for all poor tribals, they could not have gone. This aspect was there, but it has not opened the tender of for the purpose of enhancement for all who have received the compensation. That is my submission. 3.2. Reputation is when other than the above decision with respect to the appointment of arbitrator was reversed by the Honorable Supreme Court. No comments were made with respect to the merit of this case. Rather, Honorable Appeals Court declined to make any comment on the merits or demerits of the case. The land users have not produced any evidence to show that objection was raised by them within a period of 15 years. The same has also not been disputed by the land users, and sole basis to seek enhancement of compensation escapes in from the fact that Honorable Supreme Court decided to appoint an arbitrator. It is right law that any liberty which is granted to the litigant, such as in the present case, does not give rise to any right. Reliance is placed on the case of Asghar versus Mohan Verma, wherein Honorable Supreme Court has clarified that when liberty is granted to the litigant to pursue an alternative remedy as per law, then the respondent is also free to raise all defenses. The relevant portion of the judgment is reproduced as under authoritative evidence. By dismissing the special leave petition against the judgment of the High Court, this court ordered in so far as the question of compensation for improvement made by the appellant is concerned, the appellants were free to pursue an appropriate remedy for redressal of their grievance in accordance with law. This observation, as contained in order of this court, cannot be construed to mean that the respondent will be deprived of their right to set up a plea of constructive res judicata if the appellant were to raise such plea. The appellants were, as this court observed, free to pursue appropriate remedy for redressal of their grievance in accordance with law. This must necessarily be construed to mean that all defenses of the respondent upon invocation of the remedy by appellant were kept open for decision. The liberty granted by the court was not one-sided. It encompasses both the ability of the appellant to take recourse of the and of the respondent to raise necessary defense to the invocation of the remedy. Therefore, we do not find any merit in the submission or on behalf of the judgment that the earlier judgment of Kerala High Court and the order of this court preclude the respondent from raising the bar of constructive remedy. There was a case of alternative. Here also, Honorable Supreme Court only provided a forum to them.
That's right.
In light of the decision rendered by Honorable Appeals Court in Union of India as a secretary, and in absence of any evidence to show that land users had sought appointment of an arbitrator, the delay cannot be attributed to this. I take a pause and all the judgment that has been relied upon by me. There was a case that the claimant approached the authority for appointment of arbitrator, and then it was delayed. From the very all the judgment I have gone through consciously. Now here they came to be, I immediately appointed. Then the list was expanded. Then I questioned it before Honorable Patna. It was allowed in my favor. Then they reduced the list. They approached before Patna.
Initially 20 people they approached
Yes,
the High Court.
Yes.
You appointed for them.
Yes.
Appointment was made for them.
Yes.
Then what happened that
List was expanded.
expanded so much?
So much. That is the first page.
Yes.
Again, I will
List, yes sir, we have seen that.
Yes.
List was expanded
Expanded.
suo motu. You said you
Fuck.
challenged that expansion.
Yes.
You challenged that expansion in the writ petition.
Little correction would be that they first came with this who were agreed with the compensation approached this 4 petition. Then the notification itself was modified. First of all, they
I think that particular notification confining it to 20 people
20%.
was challenged. I think that was also challenged.
land users who were agreed with the compensation approached Patna High Court in reputation so and so, only for adjudication of those who approached Patna High Court. So those persons who approached Patna High Court, that was 20 in number. For them a notification was given. The aforesaid notification was modified on June 5, 1993. After this
Is it
notification,
a suo moto notification?
yes, this
suo moto
modification, which was then challenged by us.
That's right.
Then they withdrew it. Then they challenged it where they lost it within the month of case that termination should be.
Now next.
Yes. Whether the learned arbitrator has failed to take into consideration section 83 of acquisition and acquisition of the Immediate Property Act, it is submitted that objective for the enactment which pertains to the acquisition of law is different, while the acquisition under Land Acquisition Act is general for commercial and public purposes. The land which was acquired under acquisition and acquisition of the Immediate Property Act was for national interest and to regularize the land which was requisition earlier. In light of the above, section 8.3 of the Requisition and Acquisition of Immediate Property Act provides for special and distinct method of computation of compensation which is payable. Section 8.2 of the Act is introduced as under following. The compensation payable for acquisition of any property under section 7 shall be the price which the requisition property would have faced in the open market if it had remained in the same condition as it was at the time of requisitioning and been sold on the date of acquisition. This provision has been interpreted by Honorable Apex Court in the case of Dayal Singh, wherein it has been stated that Act of 1952 is self-contained code and the arbitrator must be conscious of the limitation as imposed in the Act 1952. The relevant portion of the judgment is reproduced as under forwarding. The 1952 Act is a self-contained code. 1952 Act not only lays down a criteria for determination of compensation, but also provides for mode and manner thereof. The procedure for determining the award of compensation are not the same. The provisions of Land Acquisition Act are expressly not applicable for determination of compensation under 1952. The provisions of Land Acquisition Act and 1952 Act are thus not in perimeter. Section 23 of the Land Acquisition Act 1894, on the other hand, lays down the factors which are required to be taken into consideration in determining the amount of compensation. The mode and manner in which the compensation payable for acquisition of land under the 1952 Act and the Land Acquisition Act are thus distinct and different. We fail to see as to how the provision of 28A of the Land Acquisition Act can be made applicable in relation to the proceedings under 1952 Act. This answers my exhibit 4. Shall I proceed?
That's fine. I just wanted to see section
28.
20.
28.
23 of the Land Acquisition.
Yes. Yes. Inquiry of and land acquisition award.
No, matters
It's
to be
19.
considered in determining compensation. Section 23 of the Land Acquisition.
1894. Oh, this has been.
Solatium is given under section 23 too. Is it termed as solatium 30%?
Yes, yes.
That is solatium.
That is-
Solatium word is not used in the Act.
But it is 30%. In
30%.
addition to the market, that is solution.
So, because of its compulsory nature of acquisition, this solatium is done.
Yes. And for public interest, here it is national interest. That has been the distribution. In fact, the judgment is so technical.
So, but market value is to be seen. So far as computation of market value is concerned, there is no doubt. Market
Yes.
value
No doubt.
on the
Absolutely.
date of acquisition has to be seen,
Yes.
assuming that it was in the same state when it was acquired. Correct?
That is no market value, but assuming.
You see,
No
in this particular case, no compensation has been awarded so far as the improvement in the property is concerned. No compensation has been provided for that. That the property has been improved or a building is standing thereon. No such compensation has been provided.
They say that NH is there 41, whether NH
Yes,
was there or not.
NH was always there. NH was always there.
NH is not by a different state, so whatever is the benefit.
The location of the property
Correct.
has to be taken care of.
Yes.
The location of the property, irrespective of whether it was agricultural or even if we acquire an agricultural land today, the location of the property becomes of prime importance. That we cannot ignore. The location of the property cannot be ignored. Even under any act.
So that is there.
Assuming that it is agricultural. Assuming that it is agricultural.
Land, one advantage.
And your officer also had taken a flat rate for the entire properties.
My board of but not that way.
Yes. He has treated all the lands at par with each other. For them, every land was taken as 6,000 per acre of the entire chunk.
Of very here.
No, of the entire chunk.
Entire, yes, agricultural land, then
All,
classification.
of all the villages. The rate is the same.
Dhani 1, Dhani 2, he has classified.
He has classified the rate.
Rates. But it
So
is
far
flat.
as, but it is flat
Flat.
for all the
Yes.
all the
No
acquisitions.
dispute. No dispute.
Read for the 4.3.
4.3. The provisions as interpreted by Honorable Student, they are saying when it is stated that 1922 is a self-contained code, an arbitrator must be conscious of the limitation as imposed under 1922.
So this you have already
Yes,
read.
yes.
4.3.1.
In the case at hand, the learned arbitrator has failed to ignore the fact that claimant have themselves accepted that on the date of requisition, the land in question was agricultural land. The said fact has been admitted by the land user in their cross-examination. I have indicated at question number
Yes.
19. However, despite the same, the learned arbitrator has assumed that the land is residential in nature and thereafter computed compensation on the basis of presumption of conditions. The learned arbitrator has failed to provide by any basis in respect to 10% escalation of price granted for land situated in the vicinity. It is submitted that though the principles of escalation and de-escalation may be acceptable form to compute compensation, the escalation must be done. Keeping in mind all relevant facts, the award of learned arbitrator fails to provide any basis towards 10% annually. Most of the safeguards relied upon by the learned arbitrator are all with respect to the residential plots. However, the nature of the land in the case at hand is admittedly agricultural. In 4.4. Whether award of solatium and post-award interest is it is submitted that solatium and post-award interest which have been granted by learned arbitrator are contrary to law. It is submitted that solatium and post-award interest are not prescribed under the regulation and acquisition of renewable property. The Honorable Supreme Court in Petra of Jharkhand has taken a consistent stand that no solatium or additional interest is payable in cases of land acquisition under regulation and acquisition of renewable property. In the case of the Union of
Just a
India,
moment. No solatium or additional interest. That does not mean that simple interest,
additional I say
etc.
interest on interest.
Interest.
Related.
So
That is
this is referable to interest on
no interest. It may be equal.
Want to continue?
Yes. In the case of Union of India versus Siddharth Munda, the Honorable Supreme Court has held that the landowners under the Land Acquisition Act, so and so the acquisition and acquisition of are different and interest and solatium on compensation is not legally taken. The relevant portion of the judgment is reproduced as under for ready reference. This court in Union of India versus Chabura 2003 has clearly laid down that landowners under the Land Acquisition Act vis-a-vis RAIP Act or Defence of India are not similarly situated with solution interest on the amount of compensation are not legally sustainable. The Honorable Supreme Court has reiterated the above view on basis of the judgment rendered in the case of Union of India versus Sharma. In this case, the Honorable Constitutional Bench of the Honorable Supreme Court laid down that the Act 1952 is self-contained code. The Honorable Court has expressly held that grant of solution and interest is not contemplated under the Act of 1952 and as such the same is not valid. The relevant portion of the judgment is reproduced as under forwarding. The said Act is a self-contained code. It lays down the procedure as well as machinery for determining the amount of compensation. It is not in dispute that provisions for the payment of compensation under Land Acquisition Act would not ipso facto apply to the acquisition made under this Act. The provisions of the two Acts do not also provide for the same scheme for acquisition. Hari Krishna Khoshla, a bench of 8 judges of the court, while considering the provisions of the Requisition and Acquisition of Immovable Property Act, clearly held that provisions for grant of solution and interest under the Land Acquisition Act cannot be read into the provisions of the said Act. Having regard to the provisions of Act 3, this court opined that the provisions thereof should be aimed at giving the owner just compensation on acquisition of this land, whereas under the Land Acquisition Act, lands can be acquired in terms of the doctrine of eminent domain, so long there exists underlying purpose therefore. And in that view of the matter, the factors for determination of compensation thereunder will not be similar. The land users have replied to the above by stating strong placing a strong reliance on the case of Harman's Ani versus Union of India, wherein Honorable Court had not interfered with the grant of solution of interest. It is submitted that the said judgment was passed in the light of peculiar fact that despite having requested the appointment of the arbitrator, the same was not done for 16 years. In light of the said peculiarity, the Honorable Apex Court in case of Union of India, Shadi Ram, has observed that the said decision is the same and said decision is in the same and cannot be said to be binding precedent. The Union has already submitted that in the case at hand, it cannot be held liable for any delay, as despite taking the compensation without any demur or protest, the land users had not raised any objection for, that is, whether the claimant is entitled for any enhancement in compensation. The claimants argued that this is the result.
Yes.
The claimant has argued that compensation awarded by the arbitrator is not in accordance with the law, and two important exhibits have not been taken into consideration. It has been argued that Exhibit 4 is an acquisition of the year 1971 for the land situated in Ward 5 and 6 at Ranchi. In the said acquisition proceeding, a rate which is much higher than the present was awarded to the landlord. As with respect to the said exhibit, it is submitted that the land forming subject matter of the proceeding referred to was located in Doranda. The map exhibited by the claimant themselves will show while the area of Doranda is located within the town area, the land forming subject matter of the instant dispute is outside town area. Further, the proceeding in the case of Mansoor Hassan were under the Land Acquisition Act 1894 and not under the Act of 52. This two distribution fact therefore. Then the claimant has next place reliance on Exhibit 12 to demonstrate that for acquisition which took place in the year 1954, a compensation of 1,35,000 per acre was awarded for land located in the ward number 3 of Ranchi. The said reliance is again not proper, as in the said case the land was located near Ranchi Club main road. The land was situated within town area, and unlike the land forming the subject matter of the instant case, which is admittedly situated in the
From where do you get this that the land was located near Ranchi Club? Is
That
it
is
mentioned in the exhibit itself?
Exhibit Chutia that is indicated, then the location is there. That from that it can be deduced. Ward number 3, that will be indicated. And we have verified this. So the record, otherwise string measurement can be taken from what that scale that is mentioned in the map.
No, I just want to know that this exhibit 12 was near Ranchi Club. From where do you get this?
eligible. Electricity. It is further submitted that submissions of the claimant that land forms part of ward number 4 between ward number 3 and 5 and 6, and as such the same measures is to be adopted for the land is not a proven fact. On the contrary, if map is perused, it will reveal that the land is forming subject matter of dispute is exhibit 4, and exhibit 12 is not contiguous with the land forming subject matter of the instance. In the case of Manoj Kumar, the Honorable Apex Court has submitted that a prior award is to be construed as evidence and should not be blindly followed. The relevant portion of the judgment is reproduced as under already referred. In our opinion, High Court could not have placed an outright reliance on so and so without considering the nature of transaction relied upon by the said decision. The decision could not have been applied ipso facto to the facts of the incident case. In such cases where such judgments are relied on an evidence, though they are relevant but cannot be said to be binding with respect to the determination of price, that has to depend on evidence adduced in the case. However, in the incident case, it appears that the land of Swan Singh case, so and so was situated just across the road as observed by the High Court. As such, it is relevant evidence but not binding. As such, it would have been taken into consideration due to the nearness of the area, but at the same time, what was the nature of the transaction relied upon by the case was also required to be looked into in the objective manner. Such decision in other cases cannot be adopted without examining the basis for determining the compensation whether said transaction referred to therein can be relied upon or not, and what was the distance, size, bona fide nature of transaction before such judgment awards are relied on, and for deciding the subsequent cases. It is not open to accepting determination in a mechanical manner without considering the merits. Such determination cannot be said to be binding. We have come across several decisions where the High Court is adopting previous decision as binding. The determination of compensation in each case depends upon the nature of the land and what is evidence adduced in each case. Maybe that better evidence has been adduced in latter case regarding the actual value of the property and subsequent sale after the award and before preliminary notification under section 4 are also to be considered if filed. It is not proper to ignore the evidence adduced in the case at hand. The compensation cannot be determined by blindly following the previous award judgment. It has to be considered only a piece of evidence, not beyond that. The court has to apply the judicial mind and is supposed not on to follow the previous award without due consideration of the fact and circumstances and evidence used in the case in question. The current value reflected by comparable safety is more reliable and binding on determination of my lord that comes from my lord's side. And determination of compensation in such cases award judgment relating to an acquisition made before 5 to 10 years cannot form safe basis for determination of compensation. The award and judgment in the case of other not being inter parties are not binding as precedent. Recently, we have seen the trend of the courts to follow them blindly, probably under misconception of the concept of equality and fair treatment. The court are being swayed away, and this approach in the absence of and similar nature and situation of land is causing more injustice and tantamount to giving equal treatment in case of unequal. As per situation of a village, nature of land, its value differ from distance to distance, even 2 or 3 kilometer distance. This may also be taken into account. May make material difference in value. Land abutting highway may fetch higher value, but not land situated in interior village. So flat rate for entire village, understood. But then adjacent value taken for entire village will also not come. So
No, I didn't get it. Last sentence.
it says that it adjacent to highway. So highway, suppose a village is running in at least, I suppose it is in at least in thousands of acres, village areas. Now a land situated just adjacent to the village. And we connect a highway.
So far as location is concerned, even your authorities have taken the location and maybe the agricultural nature of land in all the 4 villages were taken as 6,000. The next was, so the valuation of the property
No, but-
even on your basis. So village to village it will not vary.
Village.
It was never your case that village to village there is a difference.
What I was trying to make, that is, 3-4 parameters have been laid down in this judgment. That you cannot move to the other judgment as a binding precedent for
Certainly, that is just an example before the court.
Yes, that is an evidence. You have to place the material facts. Court has gone to the extent that if somebody has better reduced evidence, he is better placed. How can you say that you are equal to him? What material evidence was in that case? What material evidence you have brought? Now, what material evidence they have brought? Except for oral evidence, what material evidence they have brought? I am putting a question to myself. A sale deed of 63, a sale deed of 71, and a sale deed of 85. This is the three documents. Honorable Apex Court also says that you cannot go 5-10 years back and 5-10 years ahead.
And once a sale deed of that particular
Period is available. Where is the
available.
reason to go?
So I just want you to address on Exhibit 9.
No, Exhibit 9 I have addressed. My note is very clear on the point, as I cannot give concession on my argument. Your leadership is clear on the point. My submission is, if
And
at all,
in these
because it is
properties
something,
also?
he is stopped from moving out. That is one thing I will always argue. Even if I argue, they cannot argue that beyond that deed. Beyond that deed, because they have brought that deed on it. Now they are wanting to take so many things which this judgment has been deprecated.
They have whatever they had, they have produced.
They have produced.
You see, because they were in a scale,
Yes.
right? 4 was given, so they say that from 4 onwards till 20 I will give. Whatever the court decides, at least there should be an enhancement. That is the approach, rightly so. Because what matters is the money. Which, you see, बहुत सारे points argue किए जाते हैं. Right?
Understand.
Whatever clicks, it clicks. So you cannot say that merely because they have produced Exhibit 9.
No, I am not. It is on the best
Rest is
advice
not
of their
to be
counsel.
taken
They are
into
there.
consideration.
They have brought what all material evidence was before them. So to conclude by
And in these plots also, we find that there are certain constructions and all these things are there.
yes,
Because you are valued for construction, you are valued for trees. So far as those are concerned, you cannot say anything.
but it has said that before 41, the houses, after 41, what we have done, we will not do. That is what
That's
is-
right. But even as per your report, you have also valued the
Yes, yes, I have
property
valued. Yes, sir.
for
Yes.
houses, for
we say that
trees.
trees with 3 feet depth, 3 feet rooted,
Yes, that
we
you have
consider
already-
it after 41.
That's
Beyond that, we will consider it before.
So that whatever
That we
you
have
have,
valued it. We have valued it.
you have valued it. It's
So
not
to
that you
sum
have
up,
not valued it.
My argument.
Primarily, it is on the rate of the land.
Yes.
Primarily, the entire case is on the rate of the land.
Solution.
That's rate, solution, everything revolving around this.
Yes. And then one is the aspect that those who had received without anything.
Yeah, that's all.
I'm deeply obliged for this question.
Let me hear them.
Yes. Should I take you?
Yes. I have everything. Give me that pen drive.
Today itself, by
Of course.
1:30. I have instructed my office.
Of course, yes, please provide it.
Today 1:30 I will give you.
Please,
Thank you.
Yes.
very fairly, but we appreciate.
Thank you.
You have given me the written submissions.
So the written submission is
Yeah.
by my understanding.
Yesterday you were not able to place certain judgments, whatever you want to place and place.
I'm sorry. I'm sorry. Submission will be in 2 parts. The legal argument raised and objection raised by my attorney to ignore, I will address. And rest of the written submission is prepared by my attorney. So it will indicate the nitty-gritty of pagination, paragraph, etc. Broadly.
I want you to read the entire written submissions. It is not much.
Yes,
It is just 10-15 pages. The manner in which they have.
Yes,
that's
actually,
that's
I
right.
my members in the friends. That query was there. वहाँ से हमको मैं डोरना चाहिए.
हाँ.
That exhibit itself will be.
कौन सा पूरा बता देंगे प्लीज.
ना चाहिए.
पैरा नंबर खाली बता दीजिए.
हम वो दे रहे हैं.
आप आपको हाँ इसमें डाल देंगे ना.
हम
उसमें पैरा नंबर ब्रैकेट में डाल दीजिए. ये दीजिए. ये हमको वापस चाहिए.
may I first reply to the legal query in the fourth judgment, which my learned friend has given me, then I come to my written submission,
Yes.
which is very necessary. Plus, yes, the fourth judgment, and this sheet anchor argument is that about 20 others are not entitled, despite there being order passed by the Supreme Court. Supreme Court, what actually has done has revived the very basic notification which gives right to everyone, more than 600%, etc., those who were deprived of having any kind of consensus on the compensation paid to them. So once the Supreme Court has revived, it is not only and merely an opening of alternative forum, no. That right has been created by the government itself, and this notification has been revived. It has never been challenged by the Union of India. At such a belated stage, when the award has been passed, quantum has been fixed, without paying any thing thereof, we are in appeal. Whether it is open for us to argue, which is revived by the Supreme Court or by the arbitrator, he is bound by that notification. His very appointment is not through that notification only to look into the claims of everyone. So he could not go beyond his own genesis. If I am appointed here, my lord, and the courts are, in some cases, at the court officer, or my lord,
This notification was issued by whom?
by the Union of India. It's the revised notification. My ladies and kindly.
I just
Not-
want to know.
Yes.
Initially, the notification was only for 20.
20%. I'm sorry.
20%.
No, madam, may I correct my lord, because I am appearing also. My lord, may I know what is the actual situation?
Yes.
The learned ASC with great respect has not put the correct fact.
Because I remember that particular expansion of notification was also during the pendency of a writ petition.
If I'll give them, my lord, the date, everything, and the petition.
You must have mentioned it in your written submission.
No, I mentioned because it was not argued. Because there is nothing. Some first time to argue. Can you take the note, my lord? In the year 1991,
Let me just be clear on the sequence.
I'm sorry,
1991.
because in SLP I was there.
Yes, 1991.
In 1991,
Sir, please have your seat.
so, my lord, 4 writ petitions were filed before the Honorable High Court. That is CWJC number 1590/91, 2257/91, or bracket R, 2242/91, bracket R, 2252/91. These were allowed, my lord, by the High Court.
How many people were there?
There, my lord,
Sixteen people did crime.
maybe my
What was the date of disposal of this writ petition?
writ petition 12/9/1991, 11/10/1991, 31st October 1991.
This was dismissed.
No, allowed.
Allowed.
They have not contested, my lord, forcefully that there was received.
How many people were there?
I have to check.
No, you have to check me. Only some of the people were there.
But not us.
I do not know.
Not these 20 petitioners. Not these 20 petitioners, which
This means what?
the 20 petitioner against who approached the Honorable Supreme Court or High Court, they were not in these writ petitions.
This particular writ petition was filed by whom?
Filed by the some land losers.
Some land losers.
Losers.
How many of them?
I have to check. I have to check.
When will you check? This is important.
I'll see. I'll give you.
इनका रिकॉर्ड मंगाइए सब रिकॉर्ड मंगाइए ये CWDC 1590 of 91, 2257 of 91, 22242 of 91, 2232 of 91. Date of disposal है इसका 12/9/91, 11/10/91 and 31/10/91.
Then my lord, 18/12/1992. One retired judge of the Honorable High Court was appointed as an arbitrator. Three 93.
Just a moment. Arbitrator for all?
No, for these
For the
petitioners
petitioners.
who approached the Honorable High Court. That is in the notification it is written.
Okay.
3393, my lord. A request was made to the government
Who made this request?
the District Land Acquisition Officer Ranchi.
Made a request to the government.
So as to fixation of fair compensation to all land of the aforesaid village.
To all languages.
All land. In 5/6/1993, the government
This government was central government or state
no
government?
state
Okay.
5/6/1993, a further notification was issued by government of Bihar an entire acquisition land of the aforesaid village, including the land of the lord the petitioners, they approached the High Court later. This notification was, lord,
This
again,
notification, okay.
this notification by Supreme Court, lord. So it is there. Bihar's government made a recommendation that all land users are in the same category. Don't go for only those persons who approach the High Court. So, my lord, they went, agreed by the aforesaid order, defense state officer filed a writ petition.
What is the number?
It is, my lord, CWJC number 8131 of 1993.
That's right.
Then, my lord,
That was set aside.
no, that was not set aside. After pending before the after stay, that stay was granted. In the meantime, the land acquisition officer again wrote a letter that 753 names which were included by virtue of that notification against the law as defined in section 18(1) and 18(2) of Land Acquisition Act.
Then
Then, my lord, in pursuance to that letter, the 5/6/1993 notification was cancelled.
Cancel suo motu.
Sumo.
By the state government.
Then, aggrieved by the same, we approached the Honorable High Court.
Was cancelled by order dated.
While started by the notification duty. This is the persons who later dated 30th 10 1990. Further notification dated 18/11/1993.
18/11.
1993.
1993. This was challenged.
This was challenged. I am reading from the not the SLP which we have filed. So, this is the in arbitration.
This was challenged in writ petition.
This was challenged not CWJC
Number.
CWJC 2273 of 1994.
Only one writ petition.
One petition and in representative capacity.
What do you mean?
20% filed the writ petition. Each of the village. And they said that we have also representing the all.
Capacity for all the languages.
This was dismissed.
Dismissed.
We challenged
Dismissed order dated.
dismissal order dated, my lord, 10/1/2008.
10/1/2008. Yes.
Then, my lord, we
SLP.
filed the special leave petition.
SLP number.
SLP number, my lord, 20729 of 208.
20729 of 2008.
20729 of 2008.
This was disposed of by order dated.
It was disposed of by the order dated, my lord, September 25, 2012.
2012.
And kindly mark this, my lord. Leave was granted and it's converted to an appeal. First, my lord, we filed SLP asking for leave against the High Court order. Why I am saying so, my lord? The law says, as per the practice, my lord, once the leave has been granted appeal, then High Court order will merge with the Supreme Court order. We cannot cite as a precedent of the High Court order, specifically when the Supreme Court has expressed their view.
High Court order was set aside.
High Court, once the
High Court order was.
word is not there, but leave has been granted, it converted into appeal. And the word here, the High Court, in our opinion, very strangely has dismissed the petition filed by the petitioner.
So dismissal was set aside.
Yes.
Like for all practical
Yes.
purposes.
So no longer, no.
So you
In view
would
of
say the dismissal order of High Court was set aside. Therefore, the reasons for dismissal also cannot be looked into. Therefore, the reasons for dismissal of the High Court by the High Court can also not be looked into.
Yes, my lord. Otherwise, my lord, people will cite the judgment
That's it.
and
thereafter the learned arbitrator was
my lord, thereafter by learned arbitrator, one line there senior can take it. Kindly in paragraph 4, since the one of the objection was raised, how can you file 20% represent all the villages?
That's
This point was also taken in the Honorable Supreme Court. They have, because I appeared in that matter, they said the no court fee, that time 150 rupees was
That's
court fee. So here, we not see.
the locus of 20 persons to represent the entire community was turned down. Yes, that was
Turned down by
accepted.
the High Court, accepted by the Honorable Supreme Court.
That's
Yes. Para 3 and about
let me just आप उनको मेरा written submissions वापस करो.
history in award, some facts are there.
Let me give a little dictation on whatever you have said.
Yes. I am in my I am reading the SIP which has been filed. That's why
I'll just record
very
it.
first day I was taking leave from the court.
No.
Can I hand over this?
The Learned Counsel for the appellant, while referring to the background in which the learned arbitrator was appointed, has submitted that the subject matter of the instant appeal was requisitioned by the Defence of India way back in 1941-42, and while the Defence of India was in possession of the property, the land was acquired in the year 1971-72. Arising out of acquisition of land, compensation was determined, and 80% of the land users were 80% of the land users were paid the compensation by the year 1975, but they accepted it without registering any protest. He has further submitted that the land users who were aggrieved with the compensation approached the Honorable Patna High Court by filing a writ petition being CWJC number 1590 of 91, 2257 of 91 and 2252 of 91. And the state of Bihar appointed an arbitrator while notification dated 18th of December 1992 to adjudicate the claim of those persons only who had approached the Honorable High Court in their posted batch applications. He has further submitted that the posted notification was modified by notification dated 5th of June 1993, wherein all the land users, irrespective of those who had approached the High Court or not, could get their claim of compensation adjudicated. The said notification dated 5th of June 1993 was challenged before the Honorable Patna High Court by the Union of India in CWJC number 813 of 1993. And during the pendency of the writ petition, the notification dated 5th of June 1993 encompassing all the land users was cancelled, and another notification dated November 18th, 1993 was issued restricting the arbitration only with respect to those who had initially approached the Honorable High Court. The said notification dated 18th November 1993 was challenged in writ petition being CWJC number 2273 of 94, wherein the land users sought to challenge the notification on the basis of discrimination. The said writ petition was dismissed by this court by order dated 10/1/2008. The order passed in CWJC number 2273 of 94 was challenged before the Honorable Supreme Court in Civil Appeal number 7152 of 2012, and ultimately the Honorable Apex Court was pleased to appoint the learned arbitrator सुप्रीम कोर्ट से अपॉइंटमेंट हुआ था इनका.
They have Supreme Court have passed a direction to appoint an arbitrator and restoring the notification dated.
Thereafter, the Honorable Supreme Court was pleased to appoint the learned arbitrator,
What may I read?
expressing and clearly stating that the Honorable Supreme Court had not expressed any view on the merits or demerits of the case. Consequent to the judgment passed by the Honorable Supreme Court, a fresh notification dated 23rd February 2013 was issued with respect to all the land users, appointing the learned arbitrator whose award is under challenge. Correct?
One correction is, my lord, 80% people, there is no, it's not my submission, there is no record of that.
It is their submission.
But my lord has written that
It is their submission.
the appellant,
Appellant Union of India.
we are also appellant.
Right. Appellant Union of India लिखेगा ये submission में, है ना? On behalf of Union of India. The learned counsel appearing on behalf of the claimants has submitted that the sequence of events have not been correctly mentioned by the learned counsel for the Union of India. And by giving the sequence of events, the learned counsel submits that
Not in the notification, the person who approached the Honorable High Court is there.
In which
Exhibit 14,
exhibit. Initially,
initially.
in the year 1991,
Yes, ma'am. And thereafter, all the names.
how many persons are there?
It is in CWJC 1590,
Yes, how many persons are there?
Manoranjan Sahu एवं अन्य
नहीं
means
ना,
another. Many.
नहीं है.
Other.
इसमें सबका नाम दिया.
नहीं, I is not there.
And others में number of persons is also not.
बनाम यूनियन ऑफ इंडिया एवं अन्य.
That's
दूसरा है माय लॉर्ड मोहम्मद उज्जवल एवं अन्य.
कहाँ पे नाम तो सबका नहीं है ना.
लेकिन मंगड़ा उड़ाव अन्य बनाम इंडिया महानंदन महतो बनाम यूनियन ऑफ इंडिया.
पूरा डिटेल नहीं.
पूरा जमीन का डिटेल है.
अब आपको हम सुनिए, आप बैठ. थोड़ा सा इसको लिखाना जरूरी है. The learned counsel has submitted that pursuant to order passed in CWJC number 1590 of 91 / 2257 of 91 / 2252 of 91, a retired judge was appointed as arbitrator for the writ petitioners in those cases on 18/12/1992. However, the District Land Acquisition Officer Ranchi, by letter dated 3/3/1993, had requested the state government to appoint arbitrator for all the land losers with respect to the property involved in the present case. He has submitted that this was followed by issuance of a notification dated 5/6/1993 by the government of Bihar, wherein the entire land, wherein all the land losers were covered for the purposes of arbitration. However, the Union of India challenged the said notification dated 5/6/93 in CWJC number 8131 of 1993, and in the said writ petition, a stay order was granted by the High Court. And during the pendency of the writ petition, being CWJC number 8131 of 1993, the District Land Acquisition Officer again wrote a letter stating that the inclusion of name of 753 persons for the purposes of arbitration was against the provision of law. Consequently, another notification dated 18/11/1993 was issued, whereby the notification dated 5/6/1993 ये फोन जमा कर दीजिए इधर जमा करिए whereby the notification dated 5/6/1993 enlarging the scope of arbitration for all the land users was itself withdrawn, was cancelled. This was followed by another requisition being CWJC number 2273 of 94, in which 20 persons in representative capacity representing all the land users challenged the order of withdrawal dated 18/11/1993. The said requisition was dismissed by order dated 10/1/2008. Against the order passing CWJC number 2273 of 1994, SLP number 20729 of 2008 was filed before the Honorable Supreme Court, wherein the leave was granted and it was converted into Civil Appeal number 7152 of 2012. The said SLP was dismissed. The said SLP was decided by judgment dated 25th of September 2012, and the order of the High Court refusing to extend the benefit of arbitration to all the land users was set aside. The Learned Counsel has submitted that the order of the High Court, the order of the High Court did not survive for any purpose whatsoever, as the judgment had merged with the judgment passed by the Honorable Supreme Court. He has also submitted that the order of the High Court cannot be looked into for any purpose whatsoever, including the reasons of dismissal of the writ petition by the High Court. ये है आपका the Learned Counsel. अब आप बताइए. You were addressing on the legal aspect.
Yes. I'm so sorry for inconvenience.
नहीं प्लीज. ये लिखना जरूरी है क्योंकि आपके रिटन सबमिशंस में ये सीक्वेंस नहीं.
Definitely. So already once the notification means terms of reference note confined a person to do a particular thing in a particular manner, it is not open for him to scrutinize the mandate of reference number one, secondly the mandate of Supreme Court, number two for any practical purposes. So he was bound to go with the terms of reference, the claim of every claimant before him. So it is not open today for Union of India for any purposes to go beyond its own notification. This is my submission. This is the first reply. Secondly, a very strange argument is put up by the Union of India.
Wait, I want to read this notification.
Please.
Which is that exhibit? The notification.
Notification is exhibit 14.
Appointment of learned arbitrator.
While 93 notification revived because the learned arbitrator was no more, so the fresh notification was issued.
I want to see that. This notification is dated. Not exhibited.
There are 7. Page 2. Page 4. There are 7.
Yes. Let us see the 93 notification. That this will throw some light. Okay. That's
Here, 5/6/1993 notification.
it is meant for determination of compensation.
Yes. My lord is asking the by notification by which all the persons were included. That is 5/6/1993. That is executed.
So you want to say that once there is a terms of reference,
Please.
the arbitrator is bound by the terms of reference,
Absolutely.
and he has got no jurisdiction to challenge the terms of reference, nor he has got the jurisdiction to challenge his own competence with respect to his own appointment, as is contemplated under the 1996
Absolutely.
Act.
Absolutely.
Right? As is contemplated under 1990, competence is to be decided by the arbitrator himself under 1996 Act. But
That competence is not to determine the list,
that should
impartiality. 96 says
the arbitrator was precluded from arguing that he had no competence to decide the compensation.
True.
This is what you want to say.
Because in
And
96,
this reference 5693 was suo motu done by the government.
absolutely.
It is not a result of any writ order.
Any writ order, any litigation, nothing. It is not the suo motu action.
Suo motu.
It is the generosity of the state, my lord, to include all person who has not, my lord, given their agreement. I will come to the agreement later. No? The first part is whether they are to be included or not. In 1996, my lord, Arbitration Conciliation Act, when the competence of arbitration is required, my lord, he always submit that I don't have interest in the list, number one. Secondly, I am not connecting with either of the party anyway commercially into the litigation involved or the arbitration cases involved. So his impartiality is required to be. Now here in this case, the competence of a person as an arbitrator who is a retired judge is only required so that he can decide the disputes. So the competence in both the acts are entirely different. One requires, my lord, understanding of litigation, rights, claim, challenges, determination. Other requires, my lord, he is an independent person, impartial person who can decide the disputes without putting their own interest into it. Now, my lord, the second issue which is reflected here is the munsha, the judgment. He says, my lord, since the person has taken and he did not refuse within 15 days. Rule 9 is very particular, very clear. Nothing has been, my lord, expected from a person. Because when Rule 9 says, Rule 9.3 is very particular, the offer. It is never says paid. It says offer. So if someone is giving me an offer, there is a two situation, but there are two situations. Number one, the offer is given to me, I did not respond that offer at all for longer period. Let's say for 10 years, the offer is still there. I did not respond the offer for 10 years, so that delay of 10 years cannot be attributed to the government because the government has given the offer. Either you take the payment, you express the protest, or you refuse in writing to the government. This is the intent. Absent any information, government is not in a position to say anything. It is the reflection of my learned friend. Here in this case is entirely different. Offer and offer is not accepted at all. Offer is accepted under protest. Entirely different case altogether. Here in this case we accepted, but under protest, because for agreement, unlike that acquisition act, which is more the determination of compensation, Schedule 9.
Where do you derive the protest? Where do you derive this?
I'm coming to that. I'm so pleased. This act is very unique. Uniqueness in three senses. Number one, the agreement. In no other act requires any agreement between the parties or land users. Here is the agreement towards compensation. Absent agreement, it cannot be concluded final. So once you are agreed to, it is like mediation. It is sort of mediation. The disputes put up to mediation so that both parties must satisfy with the outcome of litigation. You are not rehabilitating a person who has been displaced. And that is why the just compensation with agreement is the essence of this act. And when you are reversing a payment, you are supposed to get the signature on the statutory forms and give it to the central government. Yes, this process is concluded. Absent your agreement on form, absent your information to the higher authority, this entire process cannot be said to be concluded. And therefore you are bound to appoint an arbitrator by your own. Because the section never says that you have taken a payment and then you refused within such and such date by the payment. Wording is entirely different. I will read. Rule 9 is very particular.
Nor there is any provision of invocation of arbitration by the claimant.
Definitely. I'm so pleased. I'm so grateful.
Normally, either party has to invoke arbitration. Here there is no provision for invocation.
No provision.
The moment there is no agreement, the government has to act suo motu for the purposes of appointment of arbitrator. That is why, having no relief, the writ petitions were filed.
So grateful.
Otherwise, there are processes, even in those days, there were processes for appointment of arbitrator. Although the 1940 Act as such was not applicable.
It was different. Because when I read this entire act many times, it's a beautiful act. Although it is not workable the way it was expected to be, because of our bureaucracy, which is well known for their impediments and creating hurdles.
Please pause for a moment. The Learned Counsel for the claimant has submitted that once the terms of reference was made, the learned arbitrator had no option but to fix the fair compensation which was payable to the claimants. He has further submitted that in absence of the agreement in Form K as contemplated under the Act and the Rule, indicating due acceptance of the compensation without any protest and without any further claim, merely because the claimants had received the compensation amount, the same cannot lead to a conclusion that the entire process with respect to the payment of compensation was complete. The Learned Counsel has also submitted that the respondent authorities of the authorities of the Union of India were also under an obligation to take out certain processes and inform the Union of India with regard to completion of the payment of compensation so that appropriate steps could be taken. But in the present case, no such completion process has been placed on record. He has submitted that in absence of the agreement, it cannot be said that the claimant had agreed to accept the compensation amount as offered to them.
Please, and so please. So, unless there is a statutory obligation fulfilled by the authorities, it cannot be completed. The process has been concluded or complete.
It just
Please.
missed. The Learned Council has also submitted that there is no provision under the Act and the rules by which the claimant could invoke for arbitration. The arbitrator is required to be suo motu appointed by the Union of India once the agreement is not reached. He has submitted that under such circumstances, the claimants had no option but to move the High Court under writ jurisdiction for appointment of arbitration. He has also submitted that since no agreement was available on record in Form K, the state government had rightly issued the notification for the purposes of adjudication of claim of all the land users.
And so please.
Yes, please.
So therefore, if MUNSA does not apply, equally the Dayal Singh cannot be applied. He mentioned the Dayal Singh judgment, trying to create a distinction between the situations of this case with the Dayal Singh case. Unless the process is complete, Dayal Singh is not applied. There is no question of enhancement of juris, enhancement of compensation if the compensation itself is not settled. It is not finalized. So where is the question of enhancement of compensation? Once it is given, process conclude, it is not open for anyone to go beyond their own agreement. This is a very basic law. And that is what Dayal Singh is saying. Now here in this case, the process is still to be concluded. We are still, after 70, it is not yet concluded.
The Learned Council for the appellant, the claimants, has submitted that once the process of payment of compensation was not complete, the judgment passed by Honorable Supreme Court in the case of Union of India versus Munsha and others, reported in 1995 supplementary within bracket 4, bracket 2, SCC 600 was not applicable. Consequently, the subsequent judgment following this judgment passed in the case of Union of India versus Satyavati, reported in bracket 1996, bracket 7, SCC 740, was also not applicable. The Learned Council has submitted that the judgment of Dayal Singh, where is that judgment? They are not referred to that judgment.
But he has given a copy. Respondent has given a copy of Dayal Singh rules. Maybe it is not a part of their written submission. I'm so sorry. No occasion to look into their own written submission before to get
Dayal Singh. Where is that judgment? Please provide it to me.
Yes, sir. This is the case.
The Learned Council has submitted that the judgment of Dayal Singh and others versus Union of India reported in bracket 243, bracket 2, SCC 593. Is not applicable. In as much as in the same case, the parties had entered into the agreement in the required form and there was a concluded contract between the parties.
Third, he emphasized.
No, I just, you just respond to this. that deemed acceptance. Because there is one judgment which is staring at you. Please respond to this. This Satyavati. Deemed acceptance. The concept of deemed acceptance which has been propounded in the case of Musha, and the deemed acceptance which has been accepted in the case of Satyavati. How the concept of deemed acceptance will not apply to the claimants who did not take any steps for a long period of 10 to 15 years in connection with it.
I'm sorry. There are two conditions. Once, without responding an offer at all, no offer has been replied by anyone for longer period. If for shorter period, no, the government keep trying. For longer period, government assume there is nothing to be said by the claimant. This is called deemed. It is never called accepted. Deemed acceptance has the word point, which is never acknowledged by statute, number one. Secondly, putting some word extra under the act by strength of any.
But on the face of the judgment,
Please.
when we say that there is no concept of deemed acceptance,
True.
there is no such concept. Can you say so?
Yes, of course. Why not?
No, but on the face
It
of
is
the
open for
judgment
us.
arising, it is open for you to argue, but whether the court would say
Oh,
so.
definitely.
Because on the face of the judgment which they are relying upon, one thing we would like to know, that what was the stage at which the Musha judgment had gone to the Supreme Court? Was it at the stage of appointment of arbitrator, or it was challenging the award itself?
I'll just everybody.
Because that will throw
Yes.
some light.
Yes. Of course.
Because if a person is objecting to appointment of arbitrator, and then it comes to light that there is deemed acceptance, etc., then under such circumstances the situation is very different from the adjudication under it.
Please. Everybody. Everybody. Let me complete the notes. So
Yes.
I'll look at it and. The third judgment, and very emphatically it is mentioned, Union of India versus Senate Munda.
On the point of interest.
On the point of interest on interest, compounding of interest, etc. Justice Bhandari has mentioned something without discussion, without referring anything. Albeit, my respectful submission is, it was not at all a case of interest on interest. It was a case of non-payment of award within time, and therefore the court has created a situation in case if the cutoff date is fixed and you did not pay within cutoff date 9%, it will be aggravated to 12%. So neither you paid 9%, now you are paying to willing to pay 12%, and then you are mustering courage to approach Supreme Court challenging the award, etc., which is dismissed. Contempt is filed. In contempt, the court has once extended the time to the Union of India. Again, it was not deposited. Time is lapsed. Court said nothing doing, you deposit this much of amount. So there is no interest on interest. To avoid the rigor of contempt, the order passed. They in very hurriedly manner, they deposited. They went to Supreme Court that look, I have deposited the money 9% after so much lapse of the period, and now I am being asked to deposit 12%, which is interest on interest, which is reflected by the judgment itself. So this is a misleading statement made before the Supreme Court. Even the Supreme Court has recorded the order of contempt is set aside, not the original order of award, this is 9%. So it is not interest on interest, it was the cutoff date, which is
the default clause.
It is default clause.
From where do I get that?
But it is in the judgment itself, Senate Munda. May I read if it reads?
You have placed it on record.
It
Who
is
has
not
faced
there.
it?
It
They
is
must
not-
have faced it.
Yes, it is there record.
Where do I find the Senate Munda's judgment? It is of the
If
year?
my lady say kindly, I have a copy.
No, I'll just see it from here only. Otherwise,
Okay, it's difficult to find out later.
Yeah.
I understand.
which have you placed on record, Senate Munda?
That was yesterday itself it was given my
You have not put it in the compilation.
that one was
So they are settled with 12% only because they did not follow the given timeline. And then Chhatrapati case was mentioned to show that look, solatium interest is not applicable under this act. Even I am asked to pay, and when I am paying, I am asked to pay more.
Let's read this.
Please. Please. Leave granted. We have heard the land counsel for the parties. This appeal is directed against the judgment and order dated 2/4/2009 passed by the High Court of Jharkhand at Ranchi in contempt civil case number 815 of 2007, whereby the appellants have been directed to pay the interest at the rate of 12% per annum on the awarded amounts from 2003 to 2006. The said amount was directed to be paid by 30th May 2009. So this was the award sum of the period, and kindly note the date when it was asked to deposit. Brief facts necessary for the disposal of this appeals are recapitulated as under. In the year 1986, the Union of India, after paying compensation, acquired the land belonging to the respondent for construction of camp military operation under the Requisition Acquisition of Movable Property Act 1952. The land owners, the respondents herein raised a dispute over the amount of compensation, and arbitrator was appointed. Arbitral tribunal passed an award in favor of the respondent, directing Union of India to pay compensation at the rate of 2,000 per decimal for the land and solatium at the rate of 20%, interest thereon at the rate of 9%. Please mark note, this is very important. Per annum on the balance amount payable to the respondent, arbitral tribunal further directed them amount to be payable by the respondent shall be paid within a period of 3 months from the date of passing the award. So this 3 months is not the time frame granted. Failing this, the Union of India shall have to pay interest at the rate of 12% per
It
annum.
is the rate which is modified.
Please. Because the cut-off date is important, not every time if
It is something like if you do not pay within 3 months.
I'm so pleased.
With
So I
6%. If you do not pay within 3 months, you have to pay 6% interest instead of 3%.
Correct.
Okay, then kindly read for him.
Please. The High Court, sorry.
The High Court upheld the award.
Yes. The High Court, by its order dated 27/4/2007, by upholding the award of the arbitral tribunal, reduced the post-award interest from 12% to 9% per annum. The High Court, however, directed that if the amount is not paid within a period of 3 months. So every time, my lord, when it is escalated after the period, my lord, court was leniently, my lord, considered the procedural delay of Union of India, and every time, my lord, granted concession. Yes, if you are not deposited, you please deposit. I am extending the time.
You see,
then it is-
the arbitrator, while giving the award, while giving the award, directed for making payment of interest not from the date of the award,
Yes,
but from the date of acquisition,
yes.
right? At the rate of 9%, and if it is not paid within 3 months, the rate of interest would be 12%. The High Court had only reduced the post-award interest.
Correct.
It means that till the date of the award, the 9% will be there, and the post-award interest will be reduced from 12% to 9%. It means that even the post-award interest will be only 9%. It will continue to run. And then the High Court also said that if you do not pay, then the post-award interest will be 12%.
Absolutely.
Right?
Absolutely.
Okay.
It is the cut-off date, my lady, every time the court is granted, because all of us having experience of lot the procedural delay caused by the government. Every time file from top to bottom, then permission approvals, noting, it takes time. You all have that position sometime in government, so you all know about this. So court leniently extended the time period, which is slotted by the government, and therefore the court settled them with the 12%. Court has no option. In contempt jurisdiction, neither the award can be modified nor fresh order could have been passed. So the only power left with the court is not to settle someone with the aggravation of the interest.
You read para 11 also. We are of the considered view.
We are of the considered view, the payment of interest of the rate of 12% from such and such on the amount of such
From
and
the date
such.
of award. This
Yes.
is the date of award.
Date of-
22/6/2003.
Yes, to 25/11/2006. The original.
Yes.
Yes. And amount to interest on interest.
So therefore, the court said that 12% rate of interest post award,
Please.
right, will not be payable
No,
so far as the interest component is concerned.
I'm reading it because in the meantime they have deposited. I'm just reading that.
The award, the date of award is 22/6/2003. Correct? This is the date of the award. So therefore, whatever interest would have accrued till the date of the award, the 12% interest will not be payable on that, because that would amount to payment of interest on interest. So interest component has to be kept out. This is what the book says.
Yes, I'm just reading. If the amount is not paid within a period of 3 months from the date, that is paragraph 5. From the period of the High Court, however, directed that if the amount is not paid within the period of 3 months from the date of order, the respondent will become entitled to post-award interest at the rate of 12%. So post-award interest, it's at 12% per annum. There is no further order. It's only the interest which was supposed to be paid within time, not paid, and then it is aggravated to 12%. The limit of 3 months to execute the award was extended by the High Court by another 2 months. So the time zone is not extended. Agreed by the order dated 2007 passed by the High Court, the Union of India filed a special petition before this court, which was dismissed. So the challenge against the award, etc., and the direction for payment was dismissed. It's against penalty. The respondent filed a contempt petition. So this is the order which is passed in contempt petition before the High Court of Jharkhand at Ranchi, alleging the appellants have not complied with the award passed by the arbitral tribunal and upheld by the High Court, while its order dated 27/4/2007. This is the award which is already upheld. The High Court, by the interim order, has directed the Appellant Union of India to calculate and pay the interest at the rate of 12% per annum from 2003 to 6 on the amount of such and such agreed by the aforesaid order.
This is the awarded amount inclusive of interest.
No,
Yes.
this is the award.
137,98,860.
So this was the award amount. Award was to be not paid within time. Yes.
This is the awarded amount inclusive of interest.
Please. In case if it is what is not reflected from this, interest is included. It's a contempt order.
Yes.
I need to just bear in mind. So whatever the direction given above, it is all because of the cut-off.
You read that I.
Yes. The land counsel for the respondent submit. The respondents are entitled to the interest at the rate of 12% per annum on the awarded amount. Solution and also on the amount interest as directed by the High Court. The appellant have failed to make payment within the time.
So their claim was that all the three components post award interest is to be given. That is on the awarded amount, the solution, and also
Yes.
the amount of interest.
Please, ma'am. Which
Three
is not
components of the awarded amount.
Yes, so it was never deposited. Now they were before the contempt court.
That's right.
So the contempt court may not give a settled punishment. Like if you flout the cutoff date, you are entitled to pay the
See,
interest. I understand.
just a moment. 100 rupees is the awarded amount.
Please.
Rather, let's take it this way. 50 rupees is the awarded amount. 100 rupees is the 50 rupees is the solution. Total is 100 rupees. Now there is an interest which is running on this 100 rupees. The interest will be computed till the date of the award, maybe 20%. Then till the date of the award, there are three components. One is the solution, one is the award, and other is the interest component of 20 rupees.
Okay.
So that would be 120 rupees.
True.
Correct? Now this 120 rupees, the point is whether this 20 rupees of interest will also carry post-award interest.
Please.
Because the respondent said that all the three components would carry post-award interest. It was only this part that the interest component which was forming a part of the award will not carry interest.
I'm coming to
This is what the
Yes.
Honorable Supreme Court has said.
what is reflected. I'm just coming to that. There is a missing part that this 12% is not settled by a contempt court as a punishment.
No, there is already a default clause. There is already a default clause in the order of the High Court. There is already a default clause in the order of the High Court whereby the order of the High Court reduced the rate of interest post award to 9% and with a default clause of 12%.
True.
Since they had defaulted, there was
12%.
no 12% was automatically payable.
True.
It would by default it is payable, but still the court had given them 2 months time to extension. Some extension was given. So during that extended period, they were supposed to pay only 9%, which also they did not.
Absolutely.
So in this particular case, ultimately the court held that the plea of the respondent that the interest would also carry interest has been rejected.
True.
This is how it is. And the question of payment of compound interest is not an ordinary thing.
No, I'm not saying.
So therefore there is a concept of compounding of interest in this particular. There is an adjudication to that effect. So the awarded amount will be award plus solatium. The post-award interest will run only on the award and solatium, but not on the interest component. Interest
Yes.
component will freeze,
Please.
and the rate of interest will be different.
True.
Post-award.
So it was 12%, which is reflected that as if not the 9% is paid and then not the 12% is settled.
That's
which is
right.
not a case here. It is not a case. That is not submission. So then counsel for the respondent submit that the respondents are entitled at the rate of 12% per annum on the awarded amount, solution and on the interest rate directly and on the amount of interest as directed by the High Court. The appellants have failed to make payment within the time granted by the High Court. So neither 9, neither not 10. The then counsel for the appellant submit that the respondents are entitled to be awarded amount and solution with interest at the rate of 9% per annum. She further submits that the whole amount has been paid by the appellant. So when did this amount is paid, Milord is never mentioned
That's right.
before the Supreme Court, and it is reflected as if, Milord, I already paid 9% and the 12% has been settled, Milord, apart 9%, which is not a case. This is the best representation for me, in my understanding, because it's very particular. If you have deposited, there was no occasion for High Court, Milord, to settle 12%, instead 9%
You
with the High
see, this
Court.
25/11/2006 is the date.
True.
Award is dated 22/6/2003 and the payment is dated 25/11/2006. Therefore, the court directed for making payment of 12% from 22/6/2003 to 25/11/2006 at the rate of 12% on the awarded amount and the solution. The interest is not to carry interest. This
I
is
got
it.
it. I got it. In case
That
if
is why
it
this date 25/11/2006 is coming in law.
no, 25/11/2006 is the date, Milord, to be honored by the other side. It is not the date where I have to do something. They have to deposit. They did not deposit. When did they deposit, my lord, this amount is not reflected in the judgment and it is mentioned, it is interest on interest.
Why this interest component freezes on 25/11/2006? Because that is the, apparently it is a date of payment.
Definitely.
Otherwise it would not have frozen.
True.
The Honorable Supreme Court would have said that it's to be paid till the date of payment.
True.
But the very fact that it freezes on 25/11/2006 speaks volumes.
No, definitely. Definitely. That is what I am sounding about.
So for
The cutoff date is given.
this period from the date of award till the date of payment would carry 12% interest, but the 12% interest will only be on the awarded amount and on the solation amount,
That's
but not on the component of interest.
I'm not saying
But in
interest.
the
Interest
present
is never
case,
given to us.
in the present case, the learned arbitrator has included the entire amount. That is component E. Component E has awarded amount, solation and interest. All the three components is E and 15% on E. The learned arbitrator ought to have awarded interest of 15%, the default interest, on the awarded amount and the solation, that's all. When we
So-
see it in the light of this.
No, that is not the intention of the regulation. Kindly bear in mind two things. Number one, whenever the appeal is filed, court always, because there is no provision of execution of any award, etc. 19 bars, it's become a.
Do you want to say that this award is not executable?
It is executable before the Honorable High Court. It
High
is
Court?
not High Court only. It is not a money decree. Unlike any other awards. In those awards, it can be
Under
award.
what provision of law will the High Court execute this award?
My lord, it is the
By writ
appellate.
jurisdiction.
It is appellate jurisdiction, my lord, if you wish, may kindly see section 19 and 20 of this act. Because in, my lord, land acquisition matters, every award to be treated as money decree, and therefore it is executable before the civil court. There is no bar of jurisdiction, my lord, as regards the execution of money
That is
decree.
reason.
Now in this case, section 19 is very particular, which bars not the jurisdiction of civil court for all practical purposes and for the orders to be passed under this act.
Once the order is passed,
Once
it
the
has to be
order,
executed through the.
and if my lady may kindly see section 20,
You
instant
just see
execution.
10A. 10A, the deposit is before the court. The court before whom the amount is to be deposited would be the executing court. In the manner laid down in the section 32 and 33 of the Land Acquisition Act, the amount to be deposited.
Under land acquisition, it is of course not, it becomes a money decree. But under this act, my lord, there is no concept of this award become a money decree. If my lady may kindly see, my lord, the bar of jurisdiction, section 19 under, my lord, Acquisition Act. And therefore, my lord, the penalty clause has been embedded under the act as section 20. In case if you are not depositing the amount or reversing the amount within time given by the arbitrator, then the concerned person, my lord, is attracting penalty of rupees 1,000, which is
Section
essence of
19.
19, bar of jurisdiction of the civil court, acquisition of property. Save as otherwise expressly provided in this act, so there is nothing provided. No civil court shall have jurisdiction in respect of any matter which the competent authority or the arbitrator is empowered by or under this act to determine, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in
This is
pursuance.
till the stage of arbitration, till the passing of the award. We are not on the point as to whether how would you execute the award.
Please.
Till then, till now, no steps have been taken whatsoever. Nothing you have done. You have been sleeping over it. The claimants have been sleeping. Whatever was available, whatever they could have got, even that they did not file any petition for execution. And they are absolutely clueless as to where they have to go. But I am sure if you file an execution case before me, I will not entertain it. Not much I can tell you.
Actually, no, nothing has been reflected. If my lady kindly see.
You see the rules.
Yes,
You
yes.
see the rules.
Yes.
Where the money is to be deposited. Just tell us in which court the money is to be deposited. It has to be deposited before which court? Not the High Court. Court means principal civil court of original jurisdiction in the district in which the property, requisitioned or acquired is situated, as defined under the rules. And then you just see Rule 10, how the money is to be dealt with. So money would lie in the district court, and we are going to execute it here.
Just let me do it. Because in land acquisition, it is expressly provided. The money is all the
If any person to whom an offer is made under substitute does not accept the offer or does not receive, does not within 15 days of the receipt of the offer communicate in writing to the competent authorities acceptance or otherwise of the offer, the competent person has to we submit a report to the central government by setting forth the full facts and the extent of disagreement. And he shall also forward with the report the connected by the competent authority shall at the same time deposit in the court the amount offered by him to the said person under substitution. And the court is the principal judge of civil court.
I'll look at it.
Yes, it is very, very clear. Court means the principal civil court of original jurisdiction. This High Court does not have the original jurisdiction. So we are not going to be converted into an executing court, making it clear to your litigants, right, that they should not file a petition in the High Court to get the money. And they have been sleeping over their rights.
True.
That's all.
I'm just coming. It says, Lord, the payment of compensation, section 9. Lord. The amount of compensation payable under an award shall, subject to any rule made under this Act, be paid by the competent authority to the person or person entitled thereto in such a manner, etc., etc. So it's a payment clause now. How to be paid. I will read that as it may, Lord. The Sineth Munda in no way will not apply the facts of our case. We are not never asking about anything which is not our right. Award is given, it is determined. We are here for enhancement. Post award, suasion, interest, etc. That is the component which this honorable court will take care of. So we are not saying that we need compounding of any of the interest. We are here for our basic rights.
That's right, but the award is giving you a compound interest.
This award is not in two parts. Number one, pre-award, period, delay, latches, determination, and interest, and the cut-off date, and after that, the money is retained by the government, and therefore you are entitled to pay interest. This is a capital method, this becomes a capital once the money decree method is granted. Which means the interest is not an interest any further. It is the capital. It is my own.
So therefore they have cited that judgment. We
So
will
that-
record your submission that
Yes,
it
absolutely.
forms a part of the decree, and therefore the post-award interest will also include the component of interest. But on the face of that order, it is very difficult.
My submission is in twofold. If my lady appreciate, if this amount of interest is given to me on the date when the cutoff date is fixed, it is my capital. It is no more interest. It is no more a government money. Once the award is granted, It is my money, which the government is keeping. So therefore, if you are keeping my interest with you, it is my capital which is lying with you, and therefore the interest to be borne by the government. Who else will pay? It is not the interest on interest with the original escalation. My submission is very simple. If I am entitled to A plus B plus C to be given on the D date, then that D date should be honored by the government, and that all the component, I have no business to go further if I could get my money. In case if it is not honored, then my capital, which is a C, is lying with the government. Government has to pay interest on interest. It is not the interest on interest, it is the interest on delay. It is the settled on delay. Like the solatium has no provision under this act. There is no scope for solatium interest, etc. But this is not the compensation of delay. This is not the land compensation. It is the compensation for delay. You are making delay, you have to pay. This
The Learned Counsel for the claimants has referred to the judgment passed by the Honorable Supreme Court reported in bracket 2010 bracket close 3 673 Union of India versus Senate Munda, and has submitted that the said judgment cannot be read in a manner to exclude interest on the component of interest which stood crystallized on the date of the award. He has submitted that the learned arbitrator has rightly awarded the post-award interest also by including all the three components, that is the awarded amount, the solution, and the interest component. And therefore, the post-award interest would carry interest on all the three components.
after the date of cutoff date, after the cutoff date.
After the cutoff date, as stipulated by the learned arbitrator. The learned counsel
Because
has
that entire component has become a capital for the claimant. Just
the
one line.
learned counsel has also submitted that the award passed by the learned arbitrator is essentially a money decree. Did I say so?
Yes, ma'am.
Is essentially a money decree, and
Which has to be paid within time.
which has to be paid within the stipulated time.
And so yes.
And the interest component till the date of the award partakes the character of principal amount,
And so yes.
and therefore the post-award interest will run on all the three components.
For making
That is
delays.
on all the three components, that is the award, the solution, and the interest component in the date of the award, as the claimants were entitled for immediate payment immediately after the award,
And so yes.
but having not paid so, the delayed payment interest at the rate of 15% with default clause was given by the learned arbitrator, and the same does not call for any interference rights.
Considering all the three components as a capital,
That's
which
right.
belongs to the claimant.
That's
Absolutely. Yes. The next judgment line.
Just a moment.
Yes.
He has placed the aforesaid judgment of Senate Munda in full and has submitted that the arbitral award was passed with awarded amount and solution and interest at the rate of 9% per annum on the balance amount payable to the claimants, with a default clause that if the interest is not paid, if the amount is not paid, the rate of interest would be 12% per annum. He further submits that the High Court the High Court interfered with the award of the arbitral tribunal only to the extent of reducing the post-award interest from 12% to 9%, with a default clause that if the amount is not paid within 3 months, then the post-award interest would carry interest at the rate of 12% per annum. The High Court had also extended the period for payment, but the same was not honoured by the Union of India. And in the contempt proceeding, there was a direction to pay interest at the rate of 12% from 22/6/2003 appears to be the date of award till 25/11/2006 appears to be the date of payment. And the quantified amount on which the interest was to be paid at the rate of 12% from 22/6/2003 to 25/11/2006 was rupees 1,37,98,860.08. The claimants before the Honorable Supreme Court had contended that 12% interest was payable on the awarded amount, solution, and also the amount of interest. However, the Honorable Supreme Court ultimately held that payment of 12% interest on the entire aforesaid amount from 22/6/2003 to 25/11/2006 would tantamount to payment of interest on interest, which was not permissible under the Act. And consequently, the order of the High Court in the contempt jurisdiction was set aside. The learned counsel submits that consequently, the interest at the rate of 12%, that's all, that should be sufficient.
Yes.
I will not write any
It
further.
is just like that, just for example. It is like fixed deposit. I am investing my money for a certain period, interest accrued. After that period, that money is mine, I sacrifice for a certain period, I have given to you, you utilize it, the commercial.
No, I get it. There is no problem about it.
Absolutely. So,
You see, had this order been not there, then there was no problem in buying it.
Yes,
But I have to consider this.
no, definitely.
I can't ignore it.
I know. I'm so with you, Tyson. Actually, sometimes, councils are believed. It's a responsibility of every council to put a fact in perspective and correct fact.
That's
And when you are representing a government, it's your duty to protect your subject. It should not be adversarial.
that's
Dr. Sikri's judgment, my learned friend has the next, and I was to read, but I hope my learned friend will read. He has given all the details and nitty-gritties. The word of agreement, why the agreement should be put up in the act. Agreement, and that too in the acts where the land has
which
been
is
taken.
that judgment?
That judgment is very important. Narendra Kumar versus State of Union. It's a very
So
main
it's
judgment.
already 1:30 now. So what do you propose? We can continue in the second half.
Please.
We want to conclude it today.
Please.
We will continue in the second half.
Please.
I think we will take 1 hour more. We'll continue.
I'll hardly take about 10-15 minutes.
That's right. I will be here at
So,
scheduled time.
so that's for patient hearing. Because we have.
My only concern is that whatever is due should be.
I'm so glad. I'm
Nothing
so
more.
I'm so
Page
glad.
number 70 to 27.
आपने जो
Compilation में page number 70.
हम देखेंगे अभी अभी थोड़ा लंच कर लेंगे.
So glad.
Give me some time for myself. We have a meeting also.
Can I get our compilation? I will pagination. The
हाँ,
pagination is not there.
कर दीजिए please. ये तो प्रशांत कर लेंगे.
Today's morning.
ये वाला नहीं ये